Okay, good afternoon, everyone. Welcome to the Business Services webinar, talking about the changes that are coming along in flexible hours, zero-hour contracts, and the redundancy reforms under the Employment Rights Bill. It's so today it's going to be presented by myself, James Rutley, and I'm going to be talking to Merrick Zizarek about all these reforms. Merrick has been working in employment law for over a decade now and has got lots of experience and expertise that we're hoping to tap into to see exactly what uh, employers need to know going forward on these topics. First off, though, I want to talk briefly about where we are in the timeline about when this bill is going to come into force. There's been a quite big announcement this week, so I'm just going to go back in time first. So currently we're working a lot on the Employment Rights Act of 1996, and that has been in place up until now, and it will continue to be in place, but with some alterations that are coming through with the new Employment Rights Bill. It was published last October, and it's been going through Parliament since then, and is expected to become law later this year. But an announcement this week from the government is that it'll be coming into force in three phases between 2026 and 2027. The first phase is going to be in April 2026, and this will include the policies on the screen there. So it's simplifying trade union recognition, collective redundancy protective award is being doubled, day one paternity leave and unpaid parental leave. The Fair Work Agency body is being established. There's going to be tighter whistleblowing protections and some change to statutory sick pay, and also electronic and workplace balloting is going to be introduced. Then on to phase two, which is coming in October 2026. Sorry, there's a error on the screen there. It should be October 2026. So in this stage, there's quite a few more policies coming in. Big ones being the end of fire and rehire, the employers to take all reasonable steps to prevent sexual harassment employees, and the employment tribunal time limits are being increased, which will mean that there's more time between an incident and the date at which any employee can claim for that incident, which affects us a lot in the employment law. And then onto the third phase, which will be in 2027, but they haven't specified exactly when in 2027 this is going to be introduced. So we're waiting for that announcement. And that's going to cover a lot of what well, all of what we are covering today, that being the zero-hour contract, the flexible working, and the collective redundancy thresholds. So let's get on to our main part of the presentation, talking about what is going to change in flexible hours, zero-hour contracts, and redundancy. So for this presentation, we're going to introduce a hypothetical employee, Michael Wright. So let's say that this employee, he's just finished high school, he's wanted to save some money for a year abroad, and he's looking for a job. His mum suggests going down to a local supermarket and see if they're hiring, and so he does, and luckily they are. And he gets a job there, and he's told he's going to be on a zero-hour contract, but he'd probably get about 20 hours a week to support him. And the first thing he has is an issue with which hours he'll be working, because the supermarket's open all day, and he can be given any shift in that. He wants to know if he can have some flexibility, because Michael plays hockey. He has done since he started high school. He has practice on Wednesday evenings from 6 till 8, and games are on Saturday afternoon, often involving traveling, so he's away for quite a lot of time. And if he wants to continue doing this, he asks his mum, what should he do? His mum says, just go and speak to your manager and see what they say. His manager says, we'll try and keep the hours free, but he can't guarantee it. Mirek, in this situation, what should Michael have done in order to try and get those flexible hours? And how should the employer have responded? And what's their best practice?
Yes. So first of all, good afternoon, everyone.
Goodness.
It's good to see you here. So in terms of flexible hours, now it is day one, right? So from the first day of employment. But in practice, I don't think that someone would make a request in day one, but that's what it is. So employee, if employee wants to have flexible hours, that request must be done in writing and formally. So either through some specific form that the employer might have, if they have some flexible hours policy, or through email or a letter. So verbal request is not a formal request, and the employer would need to consider such request, and they can either accommodate the flexible hours partially or fully, because obviously there may be a discussion with the employee to agree what hours are reasonable, or they can entirely refuse the request for one or more of 8 prescribed reasons. So the reasons are a burden of additional costs. So if there are any additional business costs to this, that can be refused. Detrimental effect on ability to meet customer demands. So if the business needs someone to do job, that's a good reason to refuse these flexible hours. The third one is inability to reorganize work among existing staff. So how the rota is set up, what the shifts are. The employee needs to look at the needs of all the workers there. The fourth reason is inability to recruit additional staff. So employer needs cover the hours. That's a good reason to refuse. Then the next reason is impact on quality. So if the quality of either service or product would go down because of this, that's a good reason to refuse. Then impact on performance, which is, in my view, related to quality, because if the performance gets down, the quality overall gets down too. Then it's insufficiency of work during periods the employee proposed to work. And that may be sometimes when there are periods of needs for the business to operate more longer hours. Let's say if it's a logistic business sending parcels, usually before Christmas or on a bank holiday, that may increase. Or if there is a care home and they've got more client service user to look after, that maybe as well. And the last reason is planned structural changes. So if there is any job role changes around, more employees are needed or workers, then that can be refused. And the refusal must happen also in writing within 2 months from the date the employee put the request. So there is sufficient time, in my view, to discuss the matter with the employee and to make a formal decision. So that's what should be followed. What I would like to add here, really, for best practices for employers, you need to watch out if the flexible hour request has something to do with disability discrimination or any other type of discrimination. But that would not be really flexible hours, because in my view, there's a thin line between flexible hours and reasonable adjustments, not with something different. But I would watch out for this. And also in terms, if you, let's say, refuse and give one of the 8 reasons, you need to provide reasonable explanation. Why do you think the reason is applicable? Because that's basically the new change of the new bill. That's in short the process.
Okay, great. So moving on to 0-hour contracts. Now, Michael doesn't have much financial commitments as he's still living at home and he's not having to pay rent yet, but he wants to save some money for traveling. To make sure he reaches target for the amount of money he wants raised. He knows that if he keeps working 20 hours a week, then he'll be able to reach that goal. But how can he ensure that he's getting those hours? What can he do currently under current legislation to make sure that he's keeping up, getting that money coming in? Right.
Well, so under the current legislation, there's no protection for more than 0 hours, because that's the definition of 0-hour contract. So the only benefit for the employee is that he's not exclusively bound to one employer, so he can work simultaneously for more than one employer, and he can choose for which employer he wants to work on a specific day, or he can just top up his hours that way. So the employer's best practice is to make sure that the employee understand the contract, the situation, to avoid any disputes. And also, I would say sometimes you need to watch out to not to establish a new contract by conduct, because let's say you give 0-hour contracts on the paper, but reality may be that you give 20 hours every week for last 12 months. So if the employee worked for last 12 months every week, these 20 hours, then basically he may argue that that's the new contract and those hours became regular. And there is a case law about this, and we had cases like this before where that was established. So I would watch out about how you implement and execute these the number of hours every week, I would say.
Okay. And on to redundancy. Say there's been a slow of business at this local supermarket, and there are rumours going around of possible redundancies. Could you talk us through currently what are the stages that an employer should do if they needed to conduct a redundancy or a group of redundancies, say?
Yeah, so first of all, I just would like to remind quickly what is redundancy. So redundancy situation, by definition, is either a diminished level of business or very serious business changes in terms of the structure and the job role. So some job roles could be created, some job roles could be gone, or some type of job would not be required anymore because the business is going down. So first of all, you would need to show as an employer that there is a genuine reason for redundancy. In terms of redundancy, currently employee must have 2 years of service to get redundancy pay. Those employees and workers who've got less than 2 years of service, there's a less obligations to follow the redundancy process. Just very briefly, I tried to summarize it, what's the process involved. So if there are less than 20 employees being made redundant, the process can be very simplified and you can wrap it up very quickly within 1 or 2 weeks. If there are 20 or more employees, then you need to watch out because you need to follow the group consultancy redundancy process. But generally, you would follow these steps. So establishes that the redundancy is genuine, then you need to plan in advance what to do. And then you need to choose which employees would be made redundant. So you need to create like a pool of redundancy. Then you need to either, if there are more than 20, you need to organize a group meeting. If there's less than 20, you can either do the same or you can meet everyone individually, inform them of the redundancy. You can give them a first letter confirming that the redundancy is happening. Then if you have multiple employees, you want to choose one over another, you can create like a scoring table. It is usually called matrix table, where you take into account the skills, qualifications, attendance, the performance, and those who the highest points would have priority. But you need to watch out about any employees' disabilities or pregnant employees. Then you just, after this, you may send second letter or email who's got what points and if they're still under risk of redundancy or not. Then you can organize individual meetings and provide a decision. And it is advisable to give them rights to appeal the redundancy decision. And then you would need to deal with the appeal process. And that basically is the sort of short process of the redundancy situation at present.
Okay, thank you for that, Mirek. And moving on, so now we've got an idea of what is the law as it stands today. Say in 2 years' time, when all of the law has been finally put into place, Michael's younger brother, Harry, finishes high school. He's also looking for a job, and he remembers that Michael worked at the supermarket, and he goes along and applies there. He is also given a 0-hour contract, and is told he'd probably be working about 20 hours a week if there's enough work going. He wants to start saving money before he goes to university. Going back through the same sort of situations, first with flexible hours, instead of playing hockey, Harry happens to play cricket, and he has training on Thursday and games on Sunday. What can he do to ensure he gets this time off once this legislation, the Employment Rights Bill, has gone through? What are the changes there?
Well, so basically the situation is nearly the same. So also he needs to follow the same process of written request. Employers have got 2 months to respond. They can still use one of the 8 reasons. The significant difference, though, is that if the employer use one of the reasons, there will be higher threshold of explaining why the reason is reasonable and valid reason to refuse these flexible hours. So in practice, we don't know yet how this is going to work, but I would imagine that employment tribunals would have more power to scrutinize the decision of the employer why they refuse these requests. But in reality, I think that would be a very similar process. Some employees may decide to make claims, but I would like to say, because I'm not sure if everyone is aware about this, that if employer refuse flexible request for no good reason, the employee can make a claim, but the level of compensation is maximum 8 weeks of wages. That's the equivalent. And also the employee needs to run the claim. It takes time. It may take resources. If they don't know how to do it, they need to pay solicitor. I don't think so there would be many legal firms to offer no fee for such case, because the legal costs are disproportionate to the value. So in reality, the only change would be to explain in more details why the refusal is reasonable.
So it wouldn't be a issue of a huge payout if there was an issue with flexible hours, but it might create a sort of waste time for an employment tribunal.
Absolutely, I would not say that those cases would bring high level of compensation. I think there may be more of a nuisance. So I would still sort of try to amicably resolve these at the time of the employee making the request, because as let's say you've got 20 employees and 4 of them would bring such claim, then you need to deal with 4 different claims. You need to defend it. You need to put resources, time, and legal costs for no good reason. So it's usually best to resolve it at that time internally, and that's one of the reasons why we're doing these webinars, to let you know about this.
Sure. Okay, thank you. Moving on to 0 hours. If Harry doesn't necessarily have a set target like Michael did, because he's just saving for university generally, but he likes having that amount of hours at the supermarket. Can he ensure that he has those hours more than Michael could? What is the changes that are going to be made around 0-hour contracts?
Yeah, so the proposed changes, which are not yet confirmed because they proposed or suggested changes.
Sure.
So there will be some level of guaranteed hours that need to be provided. So regardless of 0-hour contract, there will be some number of hours to be provided every week. For agency workers, the responsibility will falls on the end user. So if there is a care home using agency workers, so not the agency will be responsible, but the care home giving the job. That's I think significant change. An employer must provide a worker with access to information about their rights, if it is reasonable to consider that they might qualify within an initial information period of 2 weeks. Then there would be like a reference period to define the guaranteed regulated hours between, probably it will be 12 weeks. So usually it will be sort of calculated over 12 weeks what the minimum average hours would be. Then the employers must offer a new or valid contract that reflects the hours worked during the reference period, so the 12 weeks. How this will work in practice, we can just imagine and suspect, but it may be that this contract would need to be amended after the first 12 weeks of a worker employee being employed. So that's in very brief view. That's the changes. I don't know, James, do you think about any more points to be added?
I'd say the thing that I noticed when reading the current legislation as it is that it seems that it's every 12 weeks as well. It's not just after the initial 12 weeks, it's every 12 weeks since if they are on a 0 or low hour contract, that it seems to be that you keep having to do the checks and reference period and work out exactly what is the real contract that they're on, rather than what's on paper.
Yeah, well, I think the most important news for now is that there is no news.
Yeah.
because basically we stay with the current 0-hour legislation, and the soonest that would be implemented will be 2027. So we have 2 years time. And there are many different views. We follow different barristers and lawyers. Everyone's got different view about this, because from the question here is really from practical perspective, how you as an employer guarantee someone these hours if someone is on 0-hour contract. So that, in my view, sort of kills the purpose of 0-hour contract. So probably I would assume that the way around it is to give some sort of a part-time contract with set hours. So instead of 0-hour contract, you give let's say 16 hours or 8 hours or whatever hours are required. And then you are okay, because then you are covered by these part-time hours only. You can give more hours than as a, let's say, overtime, because in breach of the original contract, but you keep the minimum hours as a part-time hours. I think probably that is the aim of this new legislation, I would say, because otherwise it will be very difficult to just offer 0-hour contracts, because you as an employer will have obligation to provide some certain number of hours calculated over the last 12 weeks time, as you correctly said, James, because this may change every 12 weeks, basically.
Yeah. Okay, thank you. And on to our final topic. It's the redundancy reform. And I know we've been speaking a lot about this in the office, Mirik. Could you tell us if there was going to be a redundancy reform? So as this example, Harry's heard about Michael's experience with possible redundancy, and he wants to know what the situation is. Could you tell us, Mirik, going to be the big change in redundancy reform, and how is that going to work?
Well, in practice, really, there will be not significant change because we need to still follow the current redundancy process, really. The only difference would be for, I would say, large employers, because the suggested new legislation is to put an obligation of collective consultancy for redundancy process when there are at least 20 or more people to being made redundant. And for now, let's say there's a large employer, let's say a bank, and they've got multiple branches every city and town, right? So then currently, if they want to, let's say, make redundant 10 people in Leeds and 10 people in Birmingham, 10 people in London, then each of the bank is one establishment, not connected as one bank, as one employer. But the legislation will bring a change that if the number of redundancies over the whole business, including every possible branch, is over 20, then that brings new obligation. So there was also practical question about this. What is the referring period of this? Because some employers might decide to make redundancies in one branch in January, and then in the other branch, let's say, end of September the same year. So if that number would exceed 20, then you already need to think when doing the first redundancies, are you going to make further redundancies in the same year? And that question was put to the government, and I think they're still considering how to adjust the new employment rights bill in relation to this.
So what would you say would be the best practice for employers going forward with the new legislation on the horizon?
Well, I would say just keep to the script as it is now. And if for any reason you would have more than 20 people to be made redundant, then basically follow the group consultation process to be on a safe side. Other than that, there's not much to say because we don't have the definite answer. So we don't want to mislead you by giving information which we don't have ourselves, to be honest.
Sure. Okay. Now moving on to some sector-specific issues. I know there are big issues in care work and hospitality regarding sort of the 0-hour contracts and if there has to be redundancy across multiple places. Do you have any advice for employers, particularly in these industries? What would you say to them?
Well, I would say make sure you've got the paperwork in order. So make sure you've got all the contracts available. If those are 0-hour contracts, make sure that they are being updated regularly. So if, let's say, an employee started 2 years ago and that contract is from 2 years ago, it's best to revisit that contract if possible, keep it updated every year. To have policies in place, staff handbooks, that helps. And if there is any request for flexible hours, try to learn how to deal with these efficiently. If you have any of the 8 reasons to refuse, probably I would sort of think ahead about explaining why those reasons are reasonable for your specific business. So I would generally say keep your house in order and have
Sure.
updated contracts, policies, and a staff handbook.
Okay, and onto a final topic before we get to questions. I wanted to, I know you wanted to say something, Merrick, about the employment tribunal wait time, so I'll give you the floor on
Yes.
that.
Yes, that's a recent thing that we've noticed that let's say previously a simple unfair dismissal claim could take about 12 to 18 months max. So then you would wrap it up within that time. Currently, those cases are being dragged for 24 months to even 36 months. Complex disability discrimination cases, they may be going on for 4 years. For example, we have claims and cases where the final hearing is being listed in 2027. So for our clients, the employers, the businesses, you sort of are put in a situation where you have the constant claims existing and you need to think about them because some employment tribunal will be sending correspondence, something will be happening. And then you need to put the time resources to deal with these cases. So basically the system being overwhelmed, it became completely backlogged and they're not coping with it. And then the assumption or prediction is that once the new employment rights bill will come into place, there will be even more claims against employers, and that will cause even more troubles. So for you as employers, I would say make sure that you've got some sort of legal cost cover secured, because otherwise, let's say, imagine you will have 5, 6, 7 claims constantly to deal with while you run your day-to-day business, and it's becoming more and more common situation, and I just don't know where this is going to lead, but that's what it is at present.
So has it become, have these wait times come about because of less court staff or more claims, or is it just a mixture of both?
More claims, because then the law is becoming more lenient towards employees and workers and employers. So more and more employees making claims. Sometimes it could be for good reasons, but very often it is for no good reason, but they still causing the nuisance. And you as an employer need to defend those claims. So in my view, clearly it is the large, significant increase the number of claims, definitely.
Sure. Okay. Now on to questions. If anyone has a question, feel free to put it in the chat or raise your hand and we'll be able to unmute you. So anything about today's topics or the employment rights bill in general, we'll be sure to pick Murick's brain about that. Okay, we've not got any questions currently, but if any come to anyone later, then feel free to email us at enquiries@truthlegal.com and we'll be sure to reply to that. Did you have any final words, Miriam?
Thank you very much for attending. We're trying to be on top with this new bill. We will follow the changes. Definitely will do more webinars as we're expecting more and more changes happen and to be confirmed, because basically the government is now under pressure to get on with this bill because employers want to know what they're standing at, basically.
Okay. Yes. We'll be certainly do more webinars as we go along, and as it develops, as it becomes more concrete, we'll be able to fully grasp what's going on. So thank you everyone for attending.
Thank you very much.
I look forward to see you all next time. Bye.